traditional unceded and unsurrounded territory of Anishinaabe Algonquin Nation. In my capacity as the United Nations Special Rapporteur on the Rights of Indigenous Peoples, I am pleased to share my preliminary observation and recommendation at the end of my official visit to Canada that took place from the 1st to the 10th of March 2023. The purpose of my visit was to understand, in the spirit of mutual cooperation and constructive dialogue, how Canada implements the rights of Indigenous peoples in order to identify good practices and possible obstacles, and to present concrete recommendations for overcoming the challenges I observe. My final assessment and recommendation to Canada will be presented in a written report to the Human Rights Council at its 54th session later this year. Unfortunately, due to the limited time we have, my preliminary observation will not reflect the full range of issues brought to my attention, nor all the initiative of federal and provincial government related to rights of Indigenous peoples. Let me start by thanking the Government of Canada for its cooperation with my mandate, by inviting me to visit, for the welcome extended by its representatives, and for its openness and cooperation before and during the visit. I also offer my deep gratitude to Indigenous peoples who welcomed me to their territories, especially those who traveled to share their stories and concerns with me. I am inspired by their strength and determination to continue defending their rights and seeking justice. I would also like to thank the Government of Quebec, Manitoba, and British Columbia for the cooperation extended to my mandate. I regret that the Government of Alberta declined my invitation to meet, especially considering the concerning situation of Indigenous people in the province. I acknowledge the progress made by Canada towards the promotion and protection of the rights of Indigenous peoples since the visit of my predecessor in 2003 and 2013, and the many efforts by Canada to implement the recommendations. During my visit, I was informed of both good practices and possible obstacles to the promotion and protection of the rights of Indigenous peoples. I commend the Canadian government on a number of positive measures, including the passage of Bill C-15, the United Nations Declaration on the Rights of Indigenous Peoples Act, and similar law enacted by provinces of British Columbia. I encourage all provinces and territories to make similar commitments and urge all levels of government to implement this law in accordance with international human rights standards. I will be closely monitoring the process to finalize and adopt the National Action Plan for implementation of Bill C-15 in consultation with Indigenous people, and I am interested to see how Canada will harmonize the Indian Act with the rights set out in the United Nations Declaration on the Rights of Indigenous Peoples Act. Since the visit of my predecessor in 2013, the Government of Canada and its province have taken significant steps to engage meaningful negotiation to transfer governance responsibility to First Nations, Inuit and Métis authorities, and related to criminal justice, child welfare, health, and other services. I just wanted to clarify also, because I am not very clear on the division of Canada, that I always forgot to mention their territories. So it's territories and provinces. I congratulate the Government of Canada for signing self-government agreement with 3 Métis nations, the establishment of 50 self-government negotiation tables across the country is another important step toward reconciliation and overcoming the negative legacy of colonialism. For this reason, I encourage Canada to provide adequate funding for strengthening this process and promoting a nation-to-nation relationship. I further commend Canada for advancing representation of Indigenous peoples in political and public life at the highest level by appointing Indigenous women to the office of Governor General and to the Supreme Court of Canada. I welcome the final report 2015 of the Truth and Reconciliation Commission, TRC, and its 94th calls to action, and the final report 2019 of the National Inquiry of Missing and Murdered Indigenous Women and Girls, MIYWG, that include 231 calls for justice And in 2021, the government of Canada passed a legislation to mark September 30th as the National Day for Truth and Reconciliation, to observe the ongoing impact of residential schools. I encourage all provinces and territories to make the same acknowledgement. Despite the positive measures taken by Canada, Indigenous peoples continue to face serious obstacles to achieving full enjoyment of their individual and collective rights. The current human rights situation of Indigenous people in Canada cannot be fully understood without considering the legacy of residential schools and intergenerational trauma they created. Over 150,000 First Nations, Métis, and Inuit children were separated from their families and forced to attend the government-funded school between 1870s and 1997. In every place I visit, I hear about how Indian residential school, more appropriately termed institutions, fracture familial and community ties. For over 100 years, successive generations of children, many from the same communities and families, were sent to this institution and never returned in numbers that may never be fully known. This experience was largely hidden from Canada's history until 2021 discovery of 215 unmarked graves at the Kamloops Residential School captured the world's attention. Investigations into unmarked graves and effort to collect archival information have revealed numerous accounts of Indigenous children who entered residential school, hospital, and mental facilities and went missing, often with no information provided to their families. Children were subject to physical and sexual abuses, and many survivors now live with post-traumatic stress, substance abuse, depression, and other mental health issues. Access to information is critical for these families looking for closure and healing. The Catholic Church, healthcare facilities, and any other institution holding records are encouraged to disclose this documentation. I encourage Canada and the provinces to make it easier for survivors and families of missing children to access information by taking legislative and other measures. During my visit, I observed the legacy of colonialism and the history of abuse and discrimination have left survivors and their families with a deep mistrust of Canadian institutions. First Nations, Métis, and Indian people want to lead the reparation of the remains of their missing children in culturally relevant way with adequate financial support from Canada to cover the cost of forensic investigation, exhumation, and or commemoration, healing, and wellness. Numerous concerns were presented about the 2023 technical arrangement with the International Commission on Missing Persons that Canada reportedly concluded without consulting Indigenous peoples. I fully support Indigenous people call for a survivor-centered, Indigenous-led investigation to mitigate against further harm in accordance with the TRC Call to Action 76. Existing investigation process of burial sites must respect Indigenous people law and protocols relating to grieving, death, and burial practices. There is a significant need to fund culturally relevant Indigenous health and well-being support to address trauma and to remove obstacles to accessing burial sites, particularly when they are located in private lands. I welcome the federal government creation of the National Advisory Committee on Residential Schools, Missing Children and Unmarked Burials, and the appointment of an independent special interlocutor for missing children and unmarked graves and burial sites. The federal government has also provided dedicated funding for Indigenous people to undertake research to identify missing children and unmarked burials. However, concerns were expressed by Indigenous representatives that the nature of funding agreement does not allow sufficient time to conduct investigations. It's limited to communities whose land encompass residential schools and does not permit funds to be used for legal assistance, exhumation, and DNA matching. I received disturbing reports about the rise of denialism in relation to discovery of unmarked graves and call on Canada to counter misinformation about residential school with education and awareness raising. Educating the public about the history of residential school requires the preservation of large body of evidence documenting grave and systematic violation of Indigenous children's human rights who were forced to attend Canadian residential schools. The Supreme Court of Canada ordered to destroy testimonies and other records in 2027, frustrates education effort and many obstruct future attempts to collective evidence of physical, sexual, and emotional abuse and other criminal wrongdoing, including potential information about the location of unmarked burial sites. I call upon the Government of Canada to urgently act to preserve this documentation in cooperation with Indigenous peoples. Canada has taken important steps toward recognition and redress of the abuses and trauma caused by residential schools and day schools. The House of Commons unanimously recognized the residential school system as genocide on October 27, 2022, building on the 2015 finding of the Truth and Reconciliation Commission of Canada. The Government of Canada has also settled and is continuing to resolve a number of class action claims of survivors and their families. However, full resolution of residential school claim is necessary to achieve true reconciliation, including for Catholic church-run institutions and residential schools established by provinces. I call upon the government to favorably settle the claim of Métis survivors and their families. I also learned that some survivors who suffered severe trauma were not emotionally prepared to present claims by the government's deadline, but may wish to do so in the future. In accordance with the general principle of international law, that statute of limitation should not apply to grave crimes like the ones committed in residential schools. I call upon the Government of Canada to reopen the claims process for those excluded from initial settlement. Canada has embarked on an important journey towards reconciliation that must dismantle the foundation of a structural racial discrimination against Indigenous peoples. The TRC call for action have shown the way forward and should be fully implemented. As I hear during my visit, Indigenous people want the Government of Canada to respect their rights on an equal footing, including but not limited to their right to self-determination, land territories and resources, as well as the right to free, prior and informed consent. The child welfare system is continuing the removal of Indigenous children from their families and communities and reproducing the negative impact of residential schools. Despite comprising 7.7% of the Canadian population, over 53% children in care are indigenous, up to 90% in some provinces. The majority of Indigenous children removed are placed with non-Indigenous families, which often result in children losing their language, culture, identity, and family ties. Often the decision to place Indigenous children in foster care is due to lack of adequate housing on reserve and sometimes occurs without consulting Indigenous peoples. I recall that the General Comment 11 of the Convention on the Right of the Child required that best interests of the Indigenous children be interpreted by taking into account cultural consideration and in consultation with Indigenous peoples. For this reason, I welcome Canada's passage of Bill C-92, which acknowledges the right of Indigenous peoples' self-government over child welfare service. However, it is discouraging to hear that some provinces have challenged this law in the courts. Entering the child welfare system increases the risk of incarceration and of becoming murdered or missing. Indigenous youth make up 8% of the population in Canada, are incarcerated at a rate of around 50%. Canada must adopt holistic reform in consultation with Indigenous people to address the root cause of these problems including racial discrimination, poverty, inadequate housing, and the lack of culturally appropriated interpretation of the best interest of the indigenous child. Intergenerational trauma caused by a residential school and structural racial discrimination have also led to present-day crises concerning missing and murdered indigenous women and girls. During my visit, I was alarmed by reports and testimonies about missing and murdered indigenous women and girls. I welcome Canada's positive response to recommendations of my predecessor and the TRC call to Action 41 to hold a national inquiry. In 2019, the national inquiry was concluded and a final report was delivered that includes 231 calls for justice directed at governments, institutions, social services providers, industries, and all Canadians. In spite of the report of the Royal Commission on Aboriginal Peoples, 1996, TRC calls to action, 2015, the missing and murdered indigenous women and girls call for justice, 2019. The number of missing and murdered indigenous women and girls continue to increase and escalated during COVID-19 pandemic. I commend Canada for its 2021 National Action Plan and federal pathway investment of over $2.2 billion. However, indigenous people and organizations report that this is not enough to address the growing crisis and have, as a result, launched their own initiative to reduce violence against missing and murdered indigenous women and girls and diverse people. I welcome their initiatives such as the establishment of a national database to track, map, and publish cases of murdered and missing indigenous women and girls, and the creation of alert system. Of particular concern is the situation unfolding in Winnipeg, Manitoba, and the challenges that families have encountered in recovering the bodies of missing and murdered indigenous women from a local landfill. I also here pleased to investigate the situation of missing and murdered indigenous men and boys. The overrepresentation of indigenous people in the criminal justice system must be understood in the context of colonialism and the intergenerational trauma related to the residential schools. Disproportionately high rates of indigenous people in jail, in prisons, have been linked to structural racial discrimination at every level, including policing, the judicial system, and correction. Indigenous women and gender diverse people are the most impacted, representing about 50% of female incarcerated in Canada, even though they make up less than 4% of the country's population. In the central provinces, including Saskatchewan and Manitoba, the numbers are as high as 80%. Indigenous people are disproportionately held in higher security settings and have limited access to culturally appropriate and responsive rehabilitative programming and are disproportionately subject to use of force and isolation. From what I observed, specific accommodations were not in place for gender-diverse prisoners. I was informed that indigenous people are often victims of racial profiling, arbitrary and discriminatory arrest, and excessive use of force by law enforcement that, in some cases, has resulted in death. In some provinces, victims and their relatives have not found justice. The over-policing of indigenous people, coupled with a lack of diversity and representation of indigenous people in the legal system, including among judges, lawyers, and juries, has significantly contributed to their over-incarceration. For this reason, I invite Canada to support and adequately fund initiatives to create indigenous-led policing, court, and correctional services. Indigenous peoples' distrust of the criminal justice system can only be overcome by addressing structural racial discrimination and fully implementing TRC calls to action 25 to 42. In particular, I invite Canada to invest in community-based indigenous-led policies with the aim of disrupting the poverty to prison pipeline and embracing a justice strategy that includes recognition of indigenous legal system. I invite Canada to support indigenous courts with adequate resources and to implement Section 81 of the Criminal Code in consultation with indigenous peoples to create alternatives to incarceration based on indigenous legal orders. This recommendation echoed the many calls I received from indigenous people for increased and more flexible funding for health, education, housing, and social services so they can implement their own cultural informed programs. During my visit, I observed that the situation of access to economic, social, and cultural rights has not improved since the visit of my predecessor in 2013. The enduring effect of racial discrimination continued to cause displacement and dispossession of indigenous people from their lands and create situations of homelessness, low education, achievement, unemployment, depression, and suicide. Indigenous women, girls, two-spirit, lesbian, gay, and gender-diverse people, and persons with disabilities are overrepresented in almost all aspects of housing insecurity, homelessness, and poverty, and are disproportionately impacted by violence and trauma linked to precarious living situation. Indigenous peoples share with me their distress over the high level of drug use and mental illness among indigenous children and youth, which they link to the intergenerational trauma and loss of culture caused by residential schools and the ongoing impact of racial discrimination. Addressing the indigenous housing situation is paramount to overcoming the cycle of poverty, marginalization, and insecurity that indigenous persons are experiencing. Additionally, it is key component of the process of reconciliation, as the current housing crisis is direct consequence of the loss of land and territories. Indigenous people are more likely to live in substandard, overcrowded, and culturally inadequate housing than the rest of the Canadian population. This situation constitutes a barrier to secure stable employment, education, and access to social service. The Federal Housing Advocate stresses the urgent need to develop and deliver an adequately funded for indigenous by indigenous urban, rural, and northern indigenous housing strategy that will equip indigenous government to respond to housing crisis in their communities. Indigenous languages are the repository of collective knowledge, history, and memory. Language encapsulates a uniquely indigenous way of thinking and being. During the visit, indigenous residential school survivors told me that they were forbidden from speaking their indigenous language in residential schools, and in some cases were punished for it. Today, the United Nations Educational, Scientific, and Cultural Organization, UNESCO, indicated that 75% of indigenous languages in Canada are in danger to disappear. I call upon the government of Canada to adopt the necessary measures to promote language recovery, conservation, and revitalization, including implementation of TRC calls to Action 14 and 15. I refer Canada to my 2021 communication, CAN 3/2021, that expressed concern over the persistent challenges faced by Inuit in Nunavut receiving essential public services in their language in the education, healthcare, and criminal justice system. Indigenous people in Quebec expressed concern over recent legislative change affecting language of instruction that are causing indigenous children and youth to drop out of school. Bill 96, an act respecting French as the official and common language of Quebec, reinforced Quebec's Charter of the French language, which does not apply to First Nations. Despite this, the law requires indigenous high school and college students to take courses in French. Indigenous people experience the highest rate of tuberculosis and other communicable disease, chronic health conditions, and mental health issues. Indigenous people also face a unique barriers to access health services due to historical mistrust and structural racism. The tragic death of Joyce Echaquan in 2020 highlights the reality of systemic racism in the health system. Echaquan died at Joliet Hospital, nearly 300 kilometers from her community, Manawang First Nation. She recorded a video depicting racist treatment by hospital staff before she died without receiving the medical care she required. Indigenous people are calling for the adoption of the Joyce Principle to guarantee all Indigenous people the right to equitable access without discrimination to all social and health services, as well as the right to enjoy the highest attainable standard of physical, mental, emotional, and spiritual health in accordance with the UN Declaration on the Rights of Indigenous Peoples. I am particularly concerned about the forced and coerced sterilization of Indigenous women. The Truth and Reconciliation Commission, the National Inquiry on Missing and Murdered Indigenous Women and Girls in the 2021 and 2022 Senate hearing have all identified forced and coerced sterilization as part of a continuum of violence against Indigenous women in the healthcare system. I invite Canada to launch a formal investigation to establish policies and accountability mechanisms and to meet with survivors to discuss options for redress and justice. I reiterate my predecessor recommendation to remove any existing legal barriers to the effective exercise of Indigenous self-government, including those contained in the Indian Act. As Indigenous people explained to me, the Indian Act has prevented them from exercising their right to self-determination and self-government and the right to assert their identity. Currently, the federal government has the authority to decide who has First Nation status, forcibly shaping the identities of thousands of Indigenous persons. Indigenous women share with me that through sex discrimination in the Indian Act, thousands of Indigenous women and their descendants are denied status and associated benefits, including health care for themselves and their children. They expressed concern about Canada legislating their extinction by eliminating the First Nation status over time. I recognize the step taken by the Government of Canada to address this discrimination through Bill S3, but recommended further amendment to the Indian Act to eliminate the remaining discriminatory to support registration by women and their descendants newly eligible for status, and to create an affordable, reliable, timely, and accessible remedy to compensate those that have suffered the effect of discrimination. The relationship of Indigenous people with their land and territory has a central role in defining their identity as a distinct peoples. I repeatedly heard during the course of my visit that true reconciliation can only be achieved by respecting existing treaties and providing restitution and compensation for the loss of land, territories, and resources. I welcome the 2017 decision of the Supreme Court of Canada, Silacot in Nation versus British Columbia, the first declaration of Aboriginal title in Canada history. However, I was informed that due to the high cost and complex judicial and treaty negotiation processes, some Indigenous people have to abandon their land claims. Also, I hear of how trust is broken when the federal and provincial government continue exploiting land and resources while modern treaties are in the process of being negotiated. During my visit, I was informed that a large number of mega projects and Indigenous territories proceed without good faith consultation and the absence of obtaining Indigenous people free, prior, and informed consent, as in the case of Trans-Mountain Pipeline. I am also concerned about the ongoing militarization of Indigenous land and the criminalization of Indigenous human rights defenders resisting the Trans-Mountain and Coastal GasLink pipeline in British Columbia. I urge the Government of Canada to end this violation and to adopt adequate measures to guarantee Indigenous people's right to consultation and free, prior, and informed consent, and the right to land, territory, and resources. I listed two testimonies of Indigenous people in Ontario that shared the devastating health consequences of the decades of mercury contamination of the Wabigoon and English rivers, resulting in the chronic poisoning of their people, including children. I call upon the government of Canada to take all necessary steps to provide effective remedies and adequate compensation. The impact of climate change alongside hydroelectric power projects and clear-cutting of forests in the territory of Indigenous peoples in Quebec has negatively reshaped their subsistence lifestyle, leading to the loss of culturally significant species such as caribou. Now, they are fighting to maintain their cultural and indigenous knowledge and ask the provincial government to engage in a meaningful consultation to address effective remedies, including restitution of land and compensation for the loss of resources. Indigenous people are increasingly experiencing natural disaster and other emergency situations such as wildfires, flooding, deforestation, and extreme weather events, often due to or exacerbated by the activities of extractive industries. Climate change, including the threat of displacement from coastal erosion, has created new challenges for housing security. I call upon the government of Canada to consult with Indigenous people to address these challenges, including support for Indigenous-led initiatives to conserve biodiversity and prevent environmental disaster and degradation. I reiterate the finding from my 2022 thematic report to the Human Rights Council that Indigenous women are active change agents in society and champions of sustainability. Their scientific knowledge has a key role to play in safeguarding ecosystem and ensuring environmental justice and equity. Finally, I would like to stress that on several occasions, this mandate has expressed concern that Indigenous people around the world are suffering negative, sometimes devastating consequences from Canadian extractive industry, mainly mining operation. I welcome the recent creation of Canadian Ombudsperson for Responsible Enterprise, CORE, in 2019, and look with interest to future developments. I call upon Canada to recognize its extraterritorial human rights obligation to ensure that Canadian transnational companies are held accountable for human rights violations committed abroad. The obligation to protect, respect, and fulfill human rights recognized under international human rights law entails a duty on the part of the state not only to refrain from violation of human rights, but to exercise due diligence to prevent and protect individuals from abuses committed by non-state actors. I call upon the government of Canada to uphold this important principle of international law. The responsibility to respect human rights is a global standard of expected conduct for all business enterprises wherever they operated. UN guiding principle on business and human rights. And the state has extraterritorial obligation to take steps to prevent and redress infringement of this right committed abroad by business and entities over which is exercise control. I would like to end my statement by reiterating that Indigenous people and individuals should be free from any kind of racial discrimination in the exercise of their rights. Human rights are universal, indivisible, and interdependent, and all Indigenous people shall have equal rights and opportunities. I urge the government of Canada, the provinces, and territories to use this momentum to advance reconciliation based on the nation-to-nation relationship with Indigenous peoples. I would like to stress the reassurance conveyed by Canada that is working towards a transformative future that respects and protects Indigenous peoples' right to self-determination, land, territory, and resources. I thank you for your attention.
After all that you've heard, do you believe that there have been acts of genocide committed against Indigenous peoples in Canada?
Well, that is something that is not up to me to answer because my mandate doesn't ask me to qualify if it's a genocide or not genocide. I just share with you what I hear, what I read in the reports. So that is something that is not up to my mandate to qualify.
Okay, well, you've certainly laid out a number of concerning situations here. In your assessment, is the human rights situation currently facing Indigenous people acceptable in this country? And do you believe the Canadian government is doing enough to address these problems?
Well, I think that all the things that I hear from the government is going to be reflected in my report. As I explained here, I have not the opportunity, during the time, spend time, to reflect all the effort that the government are doing and all the effort that the indigenous people are doing also. And also, of course, all the problems that they are facing in this moment. To say that is enough or not enough, it's going to be after a deep analysis of all the documents that I received from the reports of the government of Canada.
Bienvenido, señor Kalitzai. Paloma Martinez, Radio Canada International, the multilingual service of CBC Radio Canada. Taking into account your urgings and your knowledge of and observations of the indigenous nations of the southern part of the continent, what common challenges and what major differences did you observe or discuss with the indigenous leaders here in these 10 days with respect to the rest of the Americas? Y le hago la pregunta también en español. Tomando en cuenta sus orígenes y su conocimiento y observaciones de las naciones indígenas del sur del continente, ¿qué desafíos comunes y diferencias principales observó o discutió con los líderes indígenas aquí en estos días en Canadá?
No hubo tiempo de discutir la situación de las experiencias entre el sur y Canadá. Canadá es un país demasiado grande para tener solamente 10 días de visita. Se necesitaría un poco más de tiempo para hacer este tipo de análisis. Me concentré esencialmente en la situación de los pueblos indígenas del Canadá. I have not enough time to discuss and to analyze the similarities between South America and Canada. During the strength of the time, 10 days is not enough to visit Canada. I think that only to visit Ontario will take 10 days, at least. So to do what we done in 10 days, my team and myself, we had not even sleep all these 10 days because reading all the documents, analyzing all the documents, and we have not enough time even to go deeply on the analysis of all the documents that we received. So we didn't have time. I concentrated specifically on what indigenous people had been sharing with me on their situation.
With the Globe and Mail. As you indicated, this is far from a new issue, but the Globe and Mail has been reporting this week on internal government documents which show that Ottawa is aware that it has created a complicated, lengthy, difficult to understand process to apply for one's status under the Indian Act. We have spoken to people who indicated that complex applications can take up to 4 years for processing. The government does acknowledge it can take up to 2 years for such processes. Some people resort to retaining lawyers to work on their applications for status. What do you make of these issues, and do you believe they could contravene Article 9 of UNDRIP with respect to the right to belong to an Indigenous community or nation?
Of course it's contravening because it's very clear that the UN Declaration is stated that each indigenous people have the right to self-identify, and I think that is some of the issues that we have to analyze. I have documents, and of course I have to compare what are the documents said, what indigenous people have sent to me, and what Article 9 is said. So we are going to take in account that, and that's why I stated that is contravene the Indian Act, the UN Declaration on Indigenous Peoples' Rights, because now the state is the one who is having the right to define who is indigenous and who is not indigenous.
Just to follow up on that, in a recent response to a Senate committee, the federal government indicated that it would not move to repeal non-liability clauses that currently prevent First Nations women who were stripped of their status through marriage to non-status men from receiving compensation. Obviously, you did just recommend that there be a process for such women to be able to receive compensation. What do you make of that? What might you encourage the government to maybe reconsider that? Or?
it's an issue that is going on. So I think that that is something that is has been taken in account by the government, but it's going also is a claim from women. So what I can say to you is that the analysis that we are going to do, also we do the documents because we have a lot of documents. We met with the National Women in Native Women Association. There is a lot of information there, and that is one of the main claims that they have. So, as I said, this is for the strength of the time. This is only my statement. It was the one that I had. We finished this at 4 o'clock in the morning today. So we have not having the time. Really, we have all the amount of document that we receive is a. I think that all the team and myself, we bought another case, each of us, to carry all the document that we receive. So that you just to give you an idea how is the amount of document that we receive in this visit. So I will analyze that situation in my report that I will submit it to the Human Rights Council in September. Yeah, go ahead. Please.
Susan Cora from the Catholic Register. You mentioned the role, it's been well documented, the role of the Catholic Church in the residential schools. Have you, during your visit to Canada, had discussions with representatives of the Catholic Church? And if so, have you made any effort to discuss with them? Because they have pledged to accompany the government of Canada in pursuit of justice.
Well, actually, no, I had not the opportunity. I never received any input from the Catholic Church or asking for an appointment. I respond and I concentrated only to those letters that have been asking for appointment with me. And I can tell you that there have been a lot of indigenous people who have not met with me, doing that. We receive a lot of invitation, even to visit the communities, but we have not have any time to meet with all the indigenous representatives. So that's why I said that some of them, they travel long distance to come to some cities, and some of the other, they asked me for a Zoom meeting, and we done our best effort to do it. So we try to cover the majority of the invitation that I received, but it was impossible to do it. But from the Catholic Church, I have not received any interest to meet with me.
Radio-Canada, Espace Autochtone. The conclusions of the last reports were far from positive, even if governmental measures existed back then. You saluted some new measures that were put in place since then, but how is the actual situation of the rights of the Aboriginal people in Canada compared to 10 years ago?
As I said, there are some new treaties. They are a very positive issue that came to my attention. But still, as I said also, there's still the majority of the recommendation is still in place in this moment. And I can say that I can take those recommendations and to put it again as a recommendation. Of course, I will just say that those recommendations are still in place, and mine will be this and this and this.
So the recommendations are different. Has the ones from 10 years ago served to something? Were they useful?
They are useful. They are useful. And the government of Canada has the duty to fulfill. So. Mm-hmm. More questions? So thank you very much to all of you. Thank you.